Hi, this is Sharon.smoot with eXp Realty, and today I want to talk to you about selling your home while you're in a Chapter 13 bankruptcy. One of the things that always surprises me is when I meet with a client or a prospective client who's in bankruptcy, and they tell me that they've spoken with several other real estate agents who have told them that they can't sell their home because they're in bankruptcy. That couldn't be further from the truth. When you file bankruptcy, all the property that you own, both real and personal, becomes property of the bankruptcy estate. And that estate is controlled by the bankruptcy trustee. So what that means for you, if you decide to sell your home, is that you've got to get permission from the bankruptcy court to do so. And there's some steps that you need to take in order to obtain that authorization or that permission. Once you retain a realtor, you need to provide your realtor with the contact information for your bankruptcy attorney, and likewise, you need to provide your bankruptcy attorney with the contact information for your realtor. You need to provide your bankruptcy attorney with authorization to speak to your realtor. That needs to be written authorization. So you would write a letter to your bankruptcy attorney that essentially says, "This letter hereby authorizes you to speak with my realtor about my Chapter 13 bankruptcy case." You need to sign it and date it and include the name and contact information for your realtor. Email that or fax that to, or drop it off at your bankruptcy attorney's office. Once you've done that, or let me backtrack, or you can provide it to your realtor and your realtor can submit that to the bankruptcy attorney. Once you've done that, your realtor is going to make contact with the bankruptcy attorney and provide the bankruptcy attorney with a copy of the listing agreement. Once the property's gone under contract, your realtor will provide your bankruptcy attorney with a copy of the purchase and sale agreement and any other supporting documentation, such as a copy of the multiple listing printout, a copy of the earnest money check or proof that the earnest money has been paid, and any other documentation that the bankruptcy attorney needs pertaining to the sale of the home. At that point, your bankruptcy attorney is going to file a motion for leave to sell with the bankruptcy court. And a hearing date will be set. And once that hearing takes place, the judge is going to make a decision as to whether or not the property can be sold. And if the court authorizes the sale of the property, they are also going to indicate how much of the net proceeds from the sale must be deposited into the bankruptcy court. And those proceeds, if the court orders some or all of the net proceeds to be turned over to the trustee, those proceeds are going to be used to pay down the debts that are part of your Chapter 13 plan. So after the closing, well, even before the closing, the closing attorney has to get a copy of the order from the bankruptcy court. And that is something that your realtor or the bankruptcy attorney will do. They'll make sure that the closing attorney has a copy of the court's order so that the closing attorney knows how much of the proceeds need to be forwarded on to the bankruptcy trustee. So that's really how the process works. You can sell your home if you're in a Chapter 13 bankruptcy. If you have any questions about selling while in Chapter 13, please feel free to reach out to me. My phone number is 678-446-5925. All of my contact information is in the description of the video, and I'd love to hear from you. Thanks so much, and have a great day. Bye-bye.